Our next set of discussion is on article number 21 under the heading of right to freedom. So right to freedom is the broader heading. I hope you remember the fundamental rights that we are doing. So you see right to freedom here. Within that 19 is covered, 20 is covered. Now we are trying to see 21. So let's first see what does it say, like the constitution, the verbatim article, and then we'll try to see the interpretations of that. It says protection of life and personal liberty. Now, the article seems to be very small in terms of the number of words used here, but it has immense significance and relevance because the two terms, life and personal liberty, here denotes ample, you would say, like opportunities, or let's say the scope of interpretation here is very wide. And therefore, we are going to discuss that in further detail, in like greater detail, I would say. So it says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. So understand what you have to remember from this point. Firstly, that it is applicable for any person, which means citizens and non-citizens. Secondly, deprivation of life and personal liberty. So there will be many dimensions to life here and many dimensions to personal liberty here. Okay, this is the second thing you'll remember. The third thing being except according to the procedure established by law. So now the question would be that what is this procedure established by law, which we'll now see. So now we move on to see the article and the explanations for it. Now, when we go for this term, we have to actually go for two of the major cases, as you can see here. One is your Gopalan case, another is your Menka case. Now, these two cases have been very significant in the context of the interpretation of this article, and everything changed with the help of these two cases. The drastic change, if you say so. Therefore, they are the landmark cases. Now, when we talk about the Gopalan case, what happened in this case was the Supreme Court was having a very narrow interpretation of this article, because as you can see, the article has not written much about it. Like the constitution makers have not written much about this article in the constitution. So यहाँ पे बहुत ज़्यादा कोई डिटेल नहीं दिया हुआ है. Now when there are not much details here, the issue is that the judiciary will interpret it as per their set of experiences and understanding. So the judiciary had a very narrow experience of this article in this first case, Gopalan case, and year भी आपको दिख रहा है, बिल्कुल बिगनिंग की ही बात है. अब यहाँ पे इन्होंने क्या बोला, that the protection available under article 21, क्योंकि ये protection की बात कर रहा है ना, deprivation की बात कर रहा है कि नहीं होना चाहिए, तो protection की बात कर रहा है. तो इन्होंने बोला that the protection available under this article will be available only against the arbitrary executive action and not from the arbitrary legislative action. So understand it. What was said under this Gopalan case, that under article 21 जिस प्रोटेक्शन की बात की जा रही है टू एनी पर्सन, दैट विल बी ओनली फॉर द एग्जीक्यूटिव एक्शंस, आर्बिट्ररी एग्जीक्यूटिव एक्शंस, बट नॉट फॉर द लेजिस्लेटिव एक्शंस. Why was it said? Because this terminology, procedure established by law, was already mentioned in the article. So the article itself was telling that no person should be deprived of life or liberty except. So the exception to this deprivation is already given here. So it is already given that if the procedure established by law is followed, then that would be exception, which means if the procedure established by law is followed, then the person can be deprived of life or personal liberty. And therefore it was interpreted in this particular case that the protection will be available only against the arbitrary executive action and not from the legislative action. This was decided. अब फिर आगे क्या बात हुई, एक और चीज़ जो कहा गया, दैट वाज दैट अ वैलिडिटी ऑफ द लॉ विच हैज़ प्रिस्क्राइब्ड अ प्रोसीजर कैन नॉट बी क्वेश्चन ऑन ग्राउंड ऑफ लॉ. आपको लगेगा कि ये क्या चीज़ है. आई टॉक ऑन दिस, जस्ट गिव मी सम टाइम, आई फिगर दिस आउट कि वेयर इट हैज़ टू बी फिट इन, एंड आई डू दैट फॉर यू. बट इट वॉज ऑल्सो सेड हियर इन दिस केस दैट द वैलिडिटी ऑफ द लॉ, जिसने एक प्रोसीजर, कोई भी लॉ बनेगा तो उस लॉ में देयर विल बी अ प्रोसीजर that whatever would be the provisions of the law, how it has to be carried out, that is the procedure established by the law. Okay, so the law which has already prescribed a procedure, that cannot be questioned on the ground of law to be unreasonable, unfair and unjust. Because अगर procedure established by law follow हो रहा है, मतलब the procedure which is given in that law is already being followed, then it cannot be questioned because it is following the text of the constitution, right? And it was also said that here article 21 mein the phrase this personal liberty refers to only liberty relating to the person or the body of the individual. So any liberty which is individualistic in nature will only be considered here. This was you can say decided in this case. And besides article 21 it was given that हम किसी भी तरीके के और पर्सनल लिबर्टी को कंसिडर नहीं करेंगे. नाउ द क्वेश्चन इज कि ये प्रोसीजर स्टैब्लिश्ड बाय लॉ है क्या. अब इस केस में क्या होता है, सी देयर आर टू थिंग्स दैट यू हैव टू नाउ स्टडी. वन इज द प्रोसीजर स्टैब्लिश्ड बाय लॉ, अनदर इज द ड्यू प्रोसेस ऑफ लॉ. ठीक है, ये दोनों चीज़ें जब हम समझेंगे तो ही विल बी गेटिंग दिस आइडिया दैट व्हाट exactly changed in the Menka case. So before we go to the Menka case, I will actually talk about the due process of law and the procedure established by the law. Now see, this due process of law, अभी ये नहीं दिया हुआ है हमारे कॉन्स्टिट्यूशन में, मतलब this is not given in the constitution, this is given in the constitution. But firstly we'll see this, that what is it, and then we'll go back to that. Now the due process of law क्या है, US constitution में दी हुई चीज़ है, ठीक है. So this is a kind of a legal requirement that the state must respect all of the legal rights which are owed to a person, and laws that states enact must conform to the laws of the land. Now you will say, what does this mean in simple language? In short, this is telling that whatever legal requirements are there, whatever legal rights are there basically with the person, state must respect all those rights, ठीक है, and also must respect any law which the states will enact to conform to the laws of land. So when you are making, basically the indirect saying is that when the state, and here of course state you know that it means different organs, so here it will mean legislature because we are talking about law making. So whatever law the legislature is making, they have to consider all the legal rights of the individual, and law related whatever aspects are there that needs to be respected. And also the laws of the land matlab that any law should be fair. So these are something which are very basic in nature, which should be followed everywhere. So it means that law should be fair, fundamental rights should be catered to, okay? Everything should be considered while making a law. So it basically talks about the due process of law, how the law making process has happened, which means in the law making process you have also considered the person's life aspects, the liberty aspect, etc. You yourself will consider all of that while making the law. तो अब क्या होता है कि if this is considered, because this is a US concept, if this is considered, which means then the actions can be taken against post legislature and executive. Because if the law making process is only done in a way which is considering the liberty and the life of the people, then therefore the legislature is also accountable, and executive to honge hi because they are executing it. Now let's get back to the procedure established by law. Now this is derived from kind of the British concept. यहाँ पर क्या है, the courts do not have the power to invalidate a law which has been made by the parliament. You know that, right? It is entirely in the hands of the parliament. तो अब यहाँ पर क्या क्वेश्चन होता है, the procedure established by law means that law जो बना गया वो किस intent से बना गया. What was the intention of making that law does not matter much. If it is fair, if it has considered fundamental rights, no. Whatever procedure it has mentioned, if that is right, if that is legally right, intent will not matter. In the due process of law, the intent will also matter because the fairness and the rights and all other aspects would be taken care of. But here what will happen, it will not seek if the laws made by parliament is fair, just, or it's just arbitrary. It's just that procedure जो establish किया जा रहा है वो सही है, that is legally right. So in this case what happens, the legislature does not become accountable. So there was this clash amongst the judiciary also, and then in the discussion also, कि अब इस केस में क्या है. अब गोपालन केस में क्या हुआ, now that you have understood about this term also and this term also, then what happened in this Gopalan case, why did they have this very narrow interpretation, was that a majority of the judges in the bench, they propounded that already if the constitution has used this expression, which is procedure established by law, will itself means that हम क्या कर रहे हैं, हम सिर्फ एग्जीक्यूटिव की अकाउंटेबिलिटी रख रहे हैं, क्योंकि इफ़ it is followed then there is an exception, which means you cannot hold the legislature accountable, right? So minority of the judges then also said that no, this we are doing just a very narrow interpretation and we should actually see it in a wider manner. But definitely if it was a minority opinion, that was not considered. But in this case, things just got overturned. Okay, what happened in this case? Supreme Court overturned the Gopalan case judgment and now they had the wider interpretation. यहाँ पर they used, despite of this term being used in the constitution, they introduced this US concept of due process of law. और उन्होंने क्या बोला कि ये जो अंडर आर्टिकल 21 है, under this whatever protection we are giving to the people of life and liberty, that will also include the protection both from the arbitrary legislative actions and the arbitrary executive actions. It was very clearly mentioned, categorically mentioned there. So now it was said that this right can be deprived by a law provided the procedure prescribed by that is reasonable, fair and just. So even if we are just following the procedure, we need to take care that it was fair, just also, reasonable, fair and just also. So arbitrary procedure, if followed, will not be considered, and therefore the protection will be available against both the arbitrary legislative and the executive actions. Okay, I hope now the basic idea of this article should be clear to you. Now when we talk about the wider interpretation, so Constitution में तो it is just given this much, not much is talked about. But Supreme Court ने multiple interpretations में आगे जाकर के बात करी. So Supreme Court ने बोला that right to life is not just, when we use the word right to life, so it just does not only mean literally that it is only about the animal existence. Here animal means you can consider humans also, like social animal. So it's not just about the mere existence, that मेरे पास जीने का अधिकार है, so I am just living, I am just alive. That is not the purpose of this right. It includes right to live with human dignity, even if it is not mentioned. Right to life में they have not mentioned anything, but it implies, because otherwise तो if somebody is just alive, that will not be sufficient. So it includes the right to live with human dignity and all those aspects of life which makes a man's life meaningful, complete and worth living. So a life should be having these components also, that it is meaningful, it is complete and it is worth living. It shouldn't be just a mere human or animal existence here. This was the Supreme Court's idea. And therefore personal liberty में भी, life के तो है ही, personal liberty में भी we have variety of lives, that you get liberty from what all things. And in subsequent cases, coming one after the other, several rights were declared as part of Article 21. So I've got the list in the book. This is the list in the book. Let's try to see. Now see what I'm going to do right now. I'll just focus on whatever is given here. Just, read that out to you. But once I finish the topic of fundamental rights, first I'll cover all the articles, right? Till 32 we'll do it. After that, what I'll do, all the issues related to fundamental rights, I will cover in the separate lecture series. So once we finish, because otherwise what will happen, there are so many issues associated. If I keep inserting that in between, it will just drag very lengthy. So what I've thought, first I'll finish जो आपका एक basic concept है articles का, that I'll do with you. After that what I'll do is कि मैं आपको एक separate lecture series पूरा बना दूंगी, and that will cover, because Article 19, like freedom of speech and expression, also had immense other aspects to it. For example, talking about right to freedom of internet related issues हो गए, sedition हो गया, hate speech हो गया, OTT platforms का media regulations हो गया, काफ़ी कुछ, there are many things that would be covered under that. RTI हो गया. And similarly, this aspect would also have many dimensions to be covered. For example, when we talk about right to life, the first thing should also be about right to die. because again, you know, the same point will be there, that only mere existence does not matter. So therefore I'll have, let's say, separate series on right to die. Then uske andar hi ek term aayega aapka euthanasia, that I'll do. When you talk about personal liberty, you will have, let's say, the concepts like privacy. जब आप privacy पढ़ोगे, right to privacy 2017 there was a judgment, Puttaswamy judgment, that will cover in detail. When we do that, you will also come across, let's say, the राइट्स ऑफ होमोसेक्सुअल्स. तो इससे निकल के आएगा आपका LGBTQI के QIA+ कम्युनिटी के बारे में. सो देर आर लाइक यू नो अ सीरीज ऑल टुगेदर दैट आर टू बी डन. सो दैट आई डू later, as I just said. Now let's just roughly see that what all rights could be covered under article, and that has happened in the subsequent cases Supreme Court has given. Like, you know, you remember basic structure doctrine, that the Supreme Court only in multiple cases have given certain elements that would constitute the basic feature of the constitution. Similarly, it comes into news every point of time ki these elements are under this aspect of life and personal liberty. So one is right to live with human dignity. That is the obvious that we have just here talked about, human dignity. Then right to decent environment, including pollution free water and air, and protection against hazardous industries. So see, living in a pure environment, or let's say pollution free, you know, water, air, environment, this is a right, this is a fundamental right. Understand the significance of it. Why are the environmentalists and the people, you know, who go for these conservation methods? So there is a reason behind that. Of course, right to livelihood, the way you want to live is your right. Right to privacy, जो अभी आपको बात करी 2017 में. Now privacy again will have, you know, although this privacy had come from the idea of Aadhaar actually, लेकिन privacy का dimensions काफ़ी बड़ा है. Then right to shelter, right to health, right to free education of up to 14 years of age, right to free legal aid, right against solitary confinement, अकेले बंद करना, speedy trial, handcuffing, हथकड़ी लगाना, inhuman treatment, delayed execution, कहते हैं ना, justice delayed is justice denied. And this is about actually not justice trial, but it is about execution, as in कि अगर लेट्स से किसी को कोई सज़ा मिली हुई है तो बस ट्रायल नहीं चलते रहना चाहिए, या अगर उसका प्रोसेस चल रहा है, अगर सज़ा भी मिल गई है तो फिर उसको जल्दी एग्जीक्यूट करना होगा, अदरवाइज उस पर्सन का लाइफ ख़राब हो रहा है, इवन इफ द पर्सन इज़ अ क्रिमिनल. Okay, anyways, we'll see actually, you know, the details of majority of them, जो मेजर वंस हैं, जो कि जिसको डिटेल में समझना ज़रूरी है. So all those interpretations we'll see in the coming videos. Then travel abroad. If you remember, when we talked about Article 19, freedom of movement, we talked about that it was the internal aspect, and the external movement, travel abroad, it is actually coming under your liberty part. Then right against bonded labor, against custodial harassment, emergency medical aid, timely medical treatment in the government hospital. Now you understand, if you're not given that, you can claim that your Article 21, the right that you get under this, you're not getting it. Right, not to be driven out of a state citizenship. Then fair trial, prisoners to have life necessities, even if they are prisoner, but the basic life necessities they should also get. Women to be treated with decency and dignity. So you can quote this actually in any women related answers. पब्लिक हैंगिंग, इसलिए आपको पता है हमारे यहाँ पब्लिक में फांसी नहीं होती है. राइट टू रोड इन द हिली एरियाज, राइट टू इन्फॉर्मेशन, ठीक है. देन रेप्यूटेशन, तो इसको तो आपको गवर्नेंस में एंड एथिक्स में, बोथ GS2 and GS4 you have to cover anyways this in detail. Then right to reputation, right to appeal from a judgment of conviction, family pension, social economic justice and empowerment, against bar fetters, appropriate life insurance policy, sleep, रात को एक सर्टेन टाइम के बाद आवाज़ नहीं हो सकती, you know, the public noise and all of that cannot happen. Freedom from the noise pollution will also be covered under that. Sustainable development opportunity, and as I said, right to die. It is not given in the book, but 2018 में right to die was also included as a fundamental right under this, and it includes passive euthanasia with a living will. So what is euthanasia? What is passive euthanasia? What is active euthanasia? Why is passive allowed and not active allowed? All of that we'll see when we do that. But as I said, we'll first finish the basic of these fundamental rights, and then all of these will figure out in the issues related to fundamental right. So I'll see you guys in the next video, where we'll continue with discussing Article 21A. Thank you so much guys. Take care till then. Bye bye.